Good afternoon, everyone. My name is Greg Barchi from the law firm of Sawyer & Wagner, LLP. I am the president of the Out of Court. Thank you, everyone, for being here today for our program hosted by the incomparable Judge Judy Chirlin of Judicate West. I just am here to introduce the program, let everybody know that MCLE certificates will be emailed within 24 hours of this program, probably even this afternoon. And with that, I'd like to hand the reins to, again, the aforementioned incomparable Judge Judy Chirlin. Thank you.
Thank you, Greg. I'm not sure what I'm incomparable to, but I appreciate the
everything else, everything and
and I'd like to welcome all of the participants that we have here to this program. I've picked 3 of the incomparable people that I know doing both arbitrations, mediations, and trial work. So first, I would like to introduce Melissa Aliotti, who practices up in the Sacramento area. So she's our diversity for today. She's our Northern Californian. Melissa came to working as a neutral after 30 years of civil litigation, specializing in all of the kind of usual civil litigation areas plus construction defect. And I say that with that tone of voice, which will be recognizable to anybody who's been involved in a construction defect case. She has been a full-time neutral since 2016 and is affiliated with Judicate West. Going in alphabetical order, I moved to Ricardo Echeverria, who is a prominent civil personal injury lawyer specializing in bad faith insurance and catastrophic injuries. He has been designated as in the top lawyers in California numerous times. And he just recently did an arbitration with me. So that put him at the top of my mind for this program, because he's a terrific lawyer, and B, he's just a classy guy. And then our third panelist is Amy Solomon, who was a very prominent personal injury lawyer in Los Angeles, doing products, professional liability, catastrophic injuries, and is now a mediator and arbitrator also with Judicate West. So that's our panel. I should mention Amy is also a former professional ballet dancer. So I just thought I would add that to the mix. Now that I saw on the news this morning, we are literally 1 year into the shutdowns that happened in the pandemic, with the pandemic. And as I've noted, as I'm sure everybody else has, the difference in the legal profession. And one of them, of course, is the expanded use of virtual technologies. We're mostly aware of Zoom, but there are others out there. And I'm curious, how, I know you all have done both mediations and arbitrations by Zoom. And Melissa, let's start with you. Give me some overall sense from you of the advantages and disadvantages of doing arbitrations or mediations by Zoom.
Absolutely. So here in Northern California, you may have heard that the Bay Area was the first to shut down very firmly, lock and key. And my initial reaction, first as a mediator, was, oh no, mediation is a full contact sport. There's no way we can take this online and be successful at it. Well, of course, here we are, as Judge Judy said, a year later, and the legal profession as a whole has been incredibly adept and adaptable in bringing this practice online. The first 3 months, every lawyer I worked with in mediation and arbitration had never done one on Zoom, and now everybody has. And in the process, I think that I know I personally, and I think most of us have learned that it is certainly as effective, and in some cases more effective, because we have people coming in from the far reaches, in my practice, of the nation, and from what I hear with others in international practice, they've got people zooming in from all over the world, and it's an incredibly efficient and effective way to manage both mediations and arbitrations. So that's just sort of my general overview.
Okay, that's great. And before we move to Amy, I should mention, which is something that I forgot to say at the beginning, and that is we will be monitoring the chat room and the Q&A. So if those of you out there listening have a question, we will try to get to it. Amy, your observations.
So tagging on to what Melissa said, so Melissa came from the northern regions that did have a quick and robust knockout lockdown, whereas Southern California was a little more laid back about it initially. So I was actually gradually brought into the technology. I was going into Judicate West offices, but little by little, more and more people were Zooming in. The very first case I did via Zoom was with a very elderly couple represented by a very elderly attorney who were extremely concerned about traveling at that time. And so we had created a way to have them appear virtually, which was news to me when I walked in that morning. And my initial dealing with virtual was, this is never going to work. And very quickly, I realized, just as Melissa did, that not only does it work, it works extremely well and efficiently.
Ricardo, opening comments?
Yeah, I guess echoing some of the sentiments from Amy and Melissa, when this first shutdown occurred, I was very skeptical of cases settling. And particularly as a plaintiff lawyer, I thought, man, if we can't get mediations in person, there's no way we'll get cases settled. And I have to say, in the last year, I was pleasantly surprised at how many cases I was able to settle. And I think the number one thing that what makes a mediation work is the motivation of the parties. And I did, the cases that I was able to settle are where the parties, both sides, were motivated to settle. Not that every one of them settled, but there was engaged in the process trying to get it done. And the forum, the platform of doing it virtually was great. It made it a lot more convenient for those cases to settle. And so I was definitely encouraged by the use of Zoom. Now, the flip side is the cases that did not settle, I will say they didn't settle not because of the platform of Zoom, it's for other reasons. And maybe the motivation of the parties is one aspect, or maybe some cases need an open courtroom. And that's just the reality. But it wasn't for it wasn't because of the platform, it was for other reasons. So I've been very pleasantly surprised with how effective the remote mediations have gone.
Have any of you had any problems with the technology? Either parties that don't that aren't sufficiently aware or sufficiently equipped for doing these remotely?
Mm-hmm. I'll start. We have at Judicate West anyway. We have some pretty good foundational instructions provided to clients, their counsel, regarding what they need to do to be ready, particularly with regard to arbitrations. It's their day in court, if you will. And so we want to make sure that they have the proper equipment and know how to use it. In the beginning, these policies were just shaping up with all of the providers. And so the challenges in the beginning were sometimes insurmountable, quite frankly, and people wound up being on the phone a lot. Not so much in mine, but these are stories that I've heard from others. The other thing that I did early on with my clients that seemed to work very well was traditionally, we have our pre-mediation phone calls, and I immediately started doing pre-mediation Zoom calls so that we had people together one-on-one or as a group to make sure that at least the attorneys were comfortable with the technology and they could help then guide their clients. Everybody seems to be pretty darn good at it now. Although I'll tell you, just this morning, I had a check-in with some of my favorite McVickersons. I meet with them every week. And one of them had this beautiful Bluetooth audio setup going, but as soon as he adjusted a zipper on his pullover, his audio went staticky. And we all had to log out and back in again. So nothing's perfect. But isn't that true in the real world too, right? We get caught in traffic, whatever. Yeah. It's the same sort of interruption.
I know I had a potential arbitration that they put over because the plaintiff is an elderly person who doesn't have any technology, and the lawyer was going to try and figure out how he could be outside of the person's house with a small device, and he just gave up. But I understand most of the providers now have people on, like Judicate West, and I know JAMS does, and I'm sure the other ones do, have people on staff to facilitate those issues. And I just, quite frankly, just had a phone call the other day with our friends at Court Call, and they actually have a platform to do the remote and to help people who need help with the technology. And they're really set up, I think, for those people doing arbitrations and mediations who aren't associated with one of the main providers who have the staff to do that. So
and that's ingenious of them. They've really found a niche there. That's a great way for Court Call to expand their footprint.
Right. Yeah, I have a warm spot in my heart for Court Call, because when the two guys who started Court Call decided that there had to be a better way than driving to Santa Ana in a rainstorm for a 5-minute court appearance. There had to be a better way, and they asked LA Superior Court for a volunteer judge who would let them try it out in their courtroom. And I was, of course, the
number one.
For those of you who are old enough, I will say I was the Mikey of the Superior Court. I was willing to try anything. So, Ricardo, I know you've done some trials in some of the areas where you've not been able to do things remotely, or you've done partially things remotely. Tell us about that.
Sure. I actually had 2 civil jury trials, both in person in 2020. Both had different issues. The first one was up in Yolo County. In fact, it was a year ago this week that we were into our second week of a jury trial when everything shut down, and our judge, rather than declaring a mistrial, asked the jury if they'd come back. And long story short, 3.5 months later, at the end of June, after recessing on March 16, the jury, 12 of our 14 jurors came back, and we got to finish that trial. So we didn't have to do the jury selection, but when we did return, all the protocols were in place. We were kind of the guinea pigs because YOLO was about to start criminal trials the following week. We only had a week left, so they kind of wanted to test us and see how it was going to work. Fortunately, we had motivated jurors to come back, but it was a situation where, in the jury box, we had 6 jurors socially distanced with plexiglass between the 2 rows, and the remaining 6 jurors behind the plaintiffs in the gallery spread out socially distanced, and another 6 seats behind the defense gallery, 3 for the plaintiff, 3 for the defense, your IT person, your client, your co-counsel. And it was just, we were allowed to wear face shields so they could see our expressions and the witness expressions. The proceedings were live streamed on YouTube, which was very helpful because I had a rebuttal expert in Seattle who could listen to the proceedings during the week. And when it came time for rebuttal, it was seamless. We just launched right into our rebuttal. It was only maybe a half hour, 40-minute witness, but it was done telephonically. It could have been done by Zoom, but it was done remotely, and it worked really smoothly. And then the other case I did, the difference is this one was in Orange County just in November when Orange County was starting to reopen and doing some limited civil trials. It was a shorter trial, but we had to do jury selection. And that's probably the biggest challenge of doing in person during this is that you could only fit 18 prospective jurors in the courtroom at a time. And Orange County did not have live streaming. So you got the remaining jurors, prospective jurors out in the hallway, not knowing what's going on. And so if you didn't get the jury picked with the first batch of 18 prospective jurors, you kick everyone out, you bring in the next batch of 18 and you start all over. And we were told, expect to do that 2 to 3 times, meaning it takes 2 to 3 days to pick a jury. What we did to help improve our chances is that both sides stipulated to a jury of 8 instead of 12, 6 out of 8 for a verdict. So it's the same ratio, and 4 peremptories each instead of 6. And we only had 1 alternate. Fortunately, we were lucky to get the jury picked with 1 prospective juror left on the first batch of 18. So we got it done in time. And the other difference there, which is, I guess, going to be the new norm, in Orange County, we were not allowed to wear shields, or I shouldn't say it, not allowed. We could, but we had to wear a mask as well. And it was strictly enforced. I mean, everybody had to wear a mask. Picking a jury where you're only looking at the eyes and listening to what they say, I will admit, was very challenging. You kind of go with your best instincts of what they're saying, but there's a lot of facial expression, body language that you're not going to get. Body language, yes, but not facial expressions. And the last thing I would say is at least what we did have in Orange County is the witnesses were surrounded by plexiglass. It kind of looked like a hockey penalty box. But once they got in there, the judge asked the witness to take off their mask. And so at least the witnesses could be seen by the jury in evaluating credibility. But, given a closing argument with a mask to jurors wearing masks, unless they're nodding their head or shaking their head, you really can't read it that well. But, in both cases, thankfully, we were able to get to a jury verdict.
You've raised an interesting question that I'm going to bring up because I do virtually all arbitrations. I'm not fond of mediations. Too much whining is my reaction. But what I've found, and I've done a number of arbitrations by Zoom, and the thing that I find is it's more challenging to evaluate the credibility of the witnesses. Even with the boxes like you all see now, it's harder for me to get a full sense of the the credibility of the witnesses. In part, most of the time I can see their expressions, although some of them have called in on the phones, and those are problematical. But I always find that evaluating credibility includes being able to see the other parties' reactions to the witness testifying, and that's a lot harder. That's a lot harder on the Zoom. When it's, to my mind, when it's, most of the issues are legal issues, and there's, contractual issues, legal issues, whatever, and there's not as much credibility involved. It's fine. And I'll call Ricardo out, because the case that I had with him was all lawyers. Yeah. And, that was fine. I could tell. Yeah. And there weren't really so much credibility issues. Everybody almost agreed on most of the facts. But where person who's been injured, and are they exaggerating, or is the doctor, discounting, whatever, it's harder to evaluate. Amy, how about you? Do you have a sense of the witnesses, how evaluating the witnesses?
Yeah, and I think as my experience with arbitrations has evolved in a virtual setting, I've sort of learned how to change things up to make it feel better. To your point, Judge Judy, you feel constrained not being able to see the reactions or the body language of opposing counsel, perhaps to another witness. I have everybody on the screen, and I can look, and I've come to feel that it's almost a distraction, and it's kind of nice to just focus on the issue, the witness, and what's coming off the stand, so to speak. And then if there's something horribly wrong with it, then counsel can come and cross-examine accordingly. And that way I'm just focused. And it sort of takes, which would make me upset as a litigator, but it takes a lot of the drama out of it in certain respects. And to that end, Ricardo's discussions of trial, to think of how to do it virtually, and taking the drama out and taking a lot of the body language out seems crazy to me. But, I think I found it challenging in the beginning, where I had a lay witness testifying, and it was very, very clear to me that his lawyer was just off camera, but doing a very good job coaching. Mm-hmm. And that became distracting to the point of really affecting the credibility. And I just called the lawyer out and said, this is not a good arrangement. And so from that point on, I realized there need to be better rules and sort of best practices, which has evolved, as Melissa said. The rules and protocols have evolved as we've gone through this last year. But I find it's a workable, effective, useful process.
What kind of rules would you have, or could you have, that would be enforceable and allow you to keep the lawyer from coaching the witness? Are you relying on good faith, or what?
So, there's a requirement that everybody is in a separate location, whether that is someone's in an office and someone's in a conference room, or they're in entirely separate buildings. With virtual backgrounds, how do you monitor that and police that 100%? I don't know. I've not to my knowledge, run into that issue once that was established. Melissa, what do you think?
Yeah, so we have, of course, expanded the oath for witnesses in virtual arbitrations so that they are affirming that they're not consulting documents that they won't share with everybody on screen. They're affirming that there's nobody else in the room. They're affirming that they're not communicating by text or otherwise with anybody else while they're testifying. The drawback, to Judge Judy's point and to yours as well, Amy, is enforceability is challenging. We don't have a bailiff, standing over the witness, making sure that he or she is complying. But we have administered an oath, and the witness has some burden of recognizing there are rules and he or she needs to be following them. So that helps.
Ricardo, any observations?
Well, I've not had to do a jury trial virtually. And I know that there are some counties that are doing them. Some are not. I guess my initial reaction was, as a plaintiff lawyer, I would be very hesitant to do a jury trial by Zoom. I think it's great for mediations. I think it can work in arbitrations. And I'm not saying no across the board. I think for the right type of civil case, and I'm thinking of a much shorter jury trial, a much simpler jury trial, it might work. But for a longer jury trial, I would be very hesitant. Number one, I'd be concerned of what jurors am I losing because they simply don't have the technology to have a Zoom. And I'm, those may be, frankly, very good plaintiff jurors who don't have that technology. So that's number one. Number two, am I really going to get a feel in jury selection of what that person's insights are, thoughts are? I haven't done it, but much to, like Your Honor, you've indicated, it's harder to read credibility through Zoom. It's part of what you're doing in jury selection is evaluating credibility, not so much for truthworthiness, but just where the person's philosophies lie, or whether they are a good juror, a bad juror, a neutral juror, and then also just trying to maintain attention. If you got a longer trial and you got witnesses, it's easy to be distracted when you're at home on Zoom. And I'd be very concerned about doing that in a jury trial setting. I'm not saying no across the board, because I think there are maybe some cases that you could do by Zoom. Like I said, a shorter one, but I have some very, I have some reservations about doing it as a jury trial, though, for the reasons I've said.
As you were talking, I was thinking one of the jury instructions, one of the things that I always told the jurors when in my pre-instruction was that they had an obligation to help each other follow the rules. The no speaking to, no talking about it, etc. And I had a trial that I did that was a year-long trial. And during the deliberations, I got a note from the jurors that one of the jurors had brought a Webster's Pocket Dictionary in to read the definition of one of the key words in the instructions. And it was one of those that means something very different in the legal context than it does in Webster's Pocket Collegiate Dictionary. And what happened, we saved a year-long trial because as this guy brought out the dictionary to read it to the definition to the other people, the juror next to him grabbed the dictionary out of his hand and somebody said, "You can't do that." And they shut things down and sent me the note. And that's the kind of juror rapport, juror obligation, juror whatever that
they're acting as a unit.
Right.
Exactly.
Yeah.
Your Honor, to piggyback on that comment, and this was just an observation that I had from the 2 jury trials I did do in person.
Mhm.
The first one, we had an incredibly motivated, incredibly united jury. They spent 2 weeks together in March, and now they were coming back 3.5 months later. And it didn't hurt that the judge empowered them to let them know they're probably the only jury hearing a case in the state of California at the end of June. And they took it seriously. But my point is, you know, especially as a plaintiff lawyer, you like to see your jurors going to lunch together and bonding. They're not talking about the case, but they're talking about each other's families and kids. And then when they go in to deliberate, they bring their personal experiences to deliberation. In Orange County, we started obviously with the pandemic and everyone's socially distanced, and these jurors were not really talking to each other. They're not going to lunch together. They're 6 feet apart from each other during the breaks, and you really didn't get that same thing. So my point then is, if you did it virtually, you're going to get virtually none of that interaction, because the jurors won't see each other outside of on the screen listening to the evidence. So the time they get the deliberations, they've never had any kind of bonding experience through the process.
Sounds to me like all good reasons why you should be mediating and arbitrating your cases. Sorry, it was right there.
Yeah.
Well, you know, I was going to say one thing about Melissa, what you just said, which is true, and this dovetails into our topic of doing things with Zoom. You know, I've been telling lawyers, think outside the box. If there's a key threshold issue in your case that both sides agree, it's either going to make or break the case. And what comes to mind immediately for me is, in dealing with some of these injury cases, if there's a minimal policy and the question is whether that policy was open or not, maybe you agree with the other side to have that adjudicated by a neutral, somebody appointed as a 638 reference judge. And you know, work out a high-low arrangement where both sides will get finality, and you can adjudicate it through Zoom, because let's face it, at that point it becomes either a bench trial, a mini bench trial, but you can on certain cases identify those threshold issues and get them adjudicated by Zoom instead of waiting for 1.5 years to wait for an open courtroom.
Right, exactly. And you're agreeing on one person who presumably has the sophistication to make those determinations, as opposed to deciding on 12 people you don't know.
Correct.
And don't know each other.
We've had a question come in the Q&A about the oath that you mentioned. I think that was you, Melissa.
Yeah.
And whether the question precisely is that a judicial council oath or some other body? Can it be circulated? And I know it's not a judicial council thing.
No, unfortunately, there has not been an official oath promulgated by the Judicial Council regarding virtual proceedings. But you're seeing me reach down into my drawer here where I keep the oath that I administer, if I may.
Sure.
I don't have it memorized. So carry on and we'll get back to it.
Okay, well, are you willing to send it out to people who are interested?
Oh, sure. Yeah, I can give it to you, Judge Judy, or to Alex at the Beverly Hills Bar Association, or Greg, however you want to work it. It's not perfect, but it's something. And I'm absolutely happy to share it, of course.
Okay, and if they can share it through the Beverly Hills Bar, that's fine. Otherwise, I happen to know the person who's asked, and if you send it to me, I can send it to her.
Okay, perfect. All right, so that's the answer for now. We'll stay on topic here.
Okay. There's a rumor that there's a COVID discount. Melissa, you want to take that on? Is that true?
Yeah, sure.
For those who have not heard this rumor.
Yeah. So unlike Amy and Ricardo, I come from a defense practice, sort of born and raised in the traditional defense practice, if you will. So I'm asked often, particularly from my plaintiff side clients, you know, are the insurers holding the purse strings tighter because of COVID and hoping that plaintiffs are going to, that their counsel will sell their clients down the river for less money, or that the plaintiffs themselves are so desperate because of loss of jobs, loss of homes, whatever it is they've suffered through this COVID environment. And I'm finding in practice, to my great relief, that there doesn't seem to be a COVID discount. I would say my cases are settling at the same rate and for the same values as they were pre-COVID. And I say it's to my relief because it would be terribly unfortunate from a human perspective to be taking advantage of these horrible circumstances to do that to people who are already down on their luck. So I'm not seeing it, but Ricardo and Amy may have a different perspective.
Amy, do you have a sense of that?
So my experience has been very similar to Melissa's. My settlements are on par with pre-COVID, pre-virtual, in terms of the percentage of cases that are resolving, and the value. I think that there's still other reasons. I think to Ricardo's earlier point, if both sides are motivated to get it done, it's going to get done. And I do not, thank goodness, run into situations where the purse string holder is sort of taunting the other side to accept something less reasonable than they're entitled to because of hard times or, sort of a take it or leave it attitude. I'm not seeing that. And there are those instances where the defense is highly motivated to resolve the case for one reason or another. Perhaps they need to close the case out for this fiscal year. They need to get it off their books. They need to, reduce the reserves that are on the books. And in those cases, they're paying very fair value for cases. I think there have been a few times where I think perhaps there was an attempt to try and buy the case off cheap, and it didn't settle then. But then in follow-up, they finally had to come up with reasonable value and the case settled.
Ricardo, what's your take on that? Do you see
Well, I don't think it's any different than it was pre-COVID. I mean, the reality is if you don't have a trial date for a year and a half, the defense may come up to you and say, hey, maybe we can settle it. And they're trying to take advantage of time being on their side. And if it doesn't settle, it doesn't settle. And it's amazing how much more money gets put on the table the closer you get to a trial date. So the fact that the pandemic has affected trial dates, yeah, that can delay it. But I've been, like I said at the beginning, pleasantly surprised that I've had cases settle where, trial date or not, there's some motivation on the other side, whether it's an insurance company that wants to get cases off their books, get them closed, get them shut, and not have open files. We've been able to do it. But, you can't really blame if the other side, wants to test to see if somebody's willing to take less because they need money now. That's just business. I could understand why they do that. But again, that's just an issue that it's part of the mix of what you take into account of what's the fair value of a case. One is the time value of money, and that's a factor in every case. I will say, for instance, like the case I did in YOLO, we had turned down the offer by the defense going into trial. And I mean, within a couple of days of us being suspended for God knows how long, I got a phone call. Hey, the offer's on the table again. You may want to reconsider it. We said no. And thankfully, we were able to come back 3.5 months later. But again, those kinds of things will happen, but it's been more the exception than the rule in my experience.
Don't hold us into suspense. Did you end up with a jury verdict better than what they had offered?
Yeah, we did. Quite a bit better.
We have another question, and this is the subject that I was just about to get into, so I'll do it by reading this question. Once we return to, quote, normality, do you see that the parties are still going to want to use Zoom for mediations or arbitrations a lot more than doing them in person? That is, do you video conferencing as do you see video conferencing as continuing into the future?
Oh, absolutely. I think we're unanimous on this. We have, we're never going back to all in person. Think about we were talking about this before we got started, just these lunchtime panels, which obviously aren't mediations and arbitrations, but these lunchtime panels, an hour out of the day sitting at your desk versus 3 hours driving to and driving back. And there's just no reason why we would go back to everything being in person. There are still some cases that truly benefit from, being able to see those scars in person, or the interaction with a probate dispute and the family members getting together as part of the value of resolving a case like that. But for the most part, when you've got, again, we'll bring up the insurance people because they're often people who are writing checks. When you've got somebody who's got 5 mediations going in a particular day, they can sit at their desk in Boston and be fully engaged in those 5 processes instead of sending the warm bodies that we had all become, unfortunately, accustomed to in the in-person process. So yeah, I do expect this to continue.
Ricardo, what do you think about that?
Well, yeah, I wholeheartedly agree that we're going to continue to see Zoom as the format to do mediations even after the pandemic restrictions are lifted. I think that there may be some cases that might benefit from in-person. Melissa touched upon one where it's, you want to see the actual scarring that actually happened. The other one I can think of, and I've not had to deal with this by Zoom, maybe I did a couple times, but where you do have multiple defendants, and sometimes it's helpful for the mediator to get the co-defendants together, break the co-defendants apart, and play off of that. That might be a little more helpful if you're in person rather than coming from one room to another. But I think Amy and Melissa can speak more directly to that. But like I said, I think it's going to be here to stay. But there's always those cases that the parties mutually may say, let's do it in person. But I think we can do a lot of it remotely.
Amy, what do you think?
Yeah, I think the last year has shown all of us in the profession how adaptable we all can be. And, much of the legal profession is steeped in sort of the old way of doing things. And the thought of remote work was absolutely abhorrent to many a lawyer I know. And here we are a year later, and it is widely not only accepted, but appreciated and supported across the board. And, particularly when you factor in the traffic issue and how much time people have to burn on freeways and roadways. It is amazing how much people have learned to embrace the virtual process. And to Ricardo's point, talking about adaptability, I had a case where I had 17 different defense interests. And in many a pre-mediation call, I found that there was a desire for everyone on the defense side to be together at times. And there were other times where they wanted the ability to step into another's room and just have a one-on-one with that. And then this whole thing needed to switch up. And so I figured out a way how to make that happen. Breakout rooms were restrictive because they don't get to have the control of movement. And so I just set up a bunch of different rooms and gave each of them keys. And they just had to promise each other that they would only enter upon permission to another person's room. And it worked beautifully. And it just, when it was over and done with, I was shocked that it actually was rather seamless. But I think with all of that we've shown ourselves over the last year, why would we just throw away what has proven to be an efficient, effective process?
You know, as you were talking, I was in with Ricardo, when Ricardo mentioned the doctor, I guess it was an expert or a doctor who testified by telephone in his trial. It occurred to me that the judges are, like lawyers, started out very skeptical of the remote proceedings, but have come along quite nicely. And it occurs to me that even in trials, even in trials that happen in person, there'll be a possibility for and a willingness to allow certain witnesses to appear by Zoom, so that you wouldn't have to, the trial lawyers wouldn't have to do those, those video clips of depositions where you start playing them in front of a jury and they fall asleep. So I would suspect that that's going to be something that you'll see in the future if you've got a doctor in Boston or an expert in Florida or wherever, that would be something.
Think of the cost savings of not having experts lined up on the bench out in the hallway during a trial, right?
Exactly.
Maybe they even stop charging for a day when they're testifying for an hour.
Oh, well,
we'll see.
Let's not get carried away. Melissa, you've done a lot of these, as I understand, done some of these construction defect cases by Zoom. Have you done in mediations and arbitrations, or just mediations?
Yes, both. And it's interesting because those people who are attending, who are familiar with construction defect, know that these cases can have upwards of 40, 50,000 documents, primarily in discovery. And as we all know, as trial lawyers, about 150 of them are actually going to be relevant to the tribunal. But that said, that's a lot of documentation to be working with share screen. And I know there are a lot of arbitrators who insist on having a binder of all of their documents, but I don't have a home office large enough to maintain binders of that many documents. So we've gotten very good at share screen. But that said, there's really not a screen that's big enough to show architectural drawings or civil engineering plans or soil engineering. There's a lot that goes into construction projects that maybe don't lend themselves quite as well to the virtual or remote process. But it works. And the parties have been satisfied with the process. I've done it a few times while we've been in lockdown. And one of them was a couple of days, one of them was 3 weeks, and it works. And the awards come out and people aren't shocked, and it all, it's satisfying.
I'm thinking that with the Beverly Hills Bar, we probably have more people who are involved in complicated financing of movies and but than construction defect. But
probably so. Those documents are 8.5 by 11 though, so the share screen works beautifully.
Right, and I was going to say the documents, as I recall from some of the cases that I had when I was on the bench, the documents in those cases may rival the number of documents we have in a construction defect case. So
I'm sure.
One observation, Judge, about that is doing share screen like we do in depositions, it works. It's not as smooth as when you're in person, but it still works. But one observation, I don't know how this would play out, but I do a lot of insurance bad faith cases, which are document intensive. And, we may have, 8-10 binders of exhibits, but when I'm in a jury trial, I have all those documents scanned into a computer, and I can call up a document, page exhibit 37, page 223, boom, it's up there. And I want the first paragraph blown up the size of the screen, and my IT person has it instantaneously. And then I also have an iPad, it switches to me, and I can circle words that are important, erase it. And really it's persuasive when you're walking a jury through a key document and what's relevant, which I haven't done it virtually. I don't know. I'm sure there's a way to do it, but it's an observation that it's seamless when we do it in trial. I don't know how seamless it would be in a virtual, but it's just an observation of one other thing to consider if you're going to do something virtually and it's a document intensive case.
Right. One of the things that I always order the lawyers to do in my pre-arbitration calls is I tell them that it's their obligation to make sure that the other side has a physical or electronic copy of everything that they are intending to use. And if it's something that's, a multi-page document, like I do a lot of employment cases. So we get the employee manuals, or in personal, the medical reports, they're obligated to identify the pages within the documents so that when we're doing it virtually, we don't have this, wait a minute, I never got that. Yes, you did. It was page, 87 of 122, et cetera.
I had a situation, to Ricardo's point, a virtual arbitration that was document intensive, and I think one side was using an IT person to assist with exactly the type of process that you outlined, Ricardo. And it was just like sitting in a courtroom or, together, and the document was called up, boom, highlighted, very seamlessly. And that's what I'm finding, and I'm sure Melissa is too, that the attorneys are getting more creative in how to best present their case in a virtual way, whether it's for mediation or arbitration, and coming up with ways, even on, I had a mediation where the attorney, instead of just using purely share screen, that then sort of wipes all the people off to the side and they are not part of the presentation, it's just the document. She figured out a way that was very clever, and I forget what the program was, that allowed her to, when she shared screen, it was her interacting with the document. So it was like a blow up, and she would go down the list of items on her blow up, and it was very interactive, and I thought it was very clever. And
yeah, I haven't seen that. That sounds great.
It was so clever.
Yeah, I would mention that in an arbitration that I just did, which I just got the closing briefs yesterday, so I can't talk about it, except that they had a court reporter, and the court reporter firm had a monitor, a guy, I don't know what they called him, but he was there, and he was the one who dealt with all the documents. So if somebody wanted X document, they just mentioned it, and this guy put it up on the screen, so that the lawyers didn't have to worry about that, and I didn't have to worry about that. But apparently I didn't realize it until I did that case. I didn't realize that was something that the court reporter firms apparently offer as a service.
Yeah, that works well too.
Yeah. We are about 5 minutes left on our time frame. Any closing thoughts Melissa, do you want to start?
Oh, sure. We were talking about the future of ADR and remote practice.
Right.
I would just encourage people to do what feels most comfortable to them with using ADR. As the world opens up, people are going to be, some will be very enthusiastic about going back in person, and others will be more reticent, understandably. But we still have to continue to do business, and you still have the duty to get your clients the justice they deserve on both sides of the table. So I think we should, as Amy said, take advantage of all that we've learned in this last year. I'm sure it would have taken 10 years for us to acclimate to this world had we not been forced into it by this pandemic. So kudos to everybody for jumping on the bandwagon, and I hope that we can continue it.
Amy?
Yeah, the more people I chat with, the more I realize that the pandemic has probably created a larger portion of agoraphobic people. It's so interesting to sort of compare notes with people. What are they doing with their lives? Do they travel outside their houses? How do they feel about it?
Mm-hmm.
And it is amazing how many people are now, as we're getting vaccinated little by little, and sort of the light is shining somewhere at the end of some tunnel, people are now starting to get increasingly anxious, I'm finding. And so it's going to be a process for all of us. Like Melissa says, some of us are going to venture out because we've been, just held back and jailed. But there are going to be a lot of people who are quite reticent. And for that reason, I think this is here to stay.
Ricardo?
Well, I go back to the adage that the more things change, the more they stay the same. The one thing about this profession, irrespective of pre-pandemic or post-pandemic, that you can never forget is preparation. And, that means preparation for a mediation. I represent plaintiffs, but I spend time with the plaintiff, my client, walk through the pluses, the minuses, the good parts of the case, the bad parts of the case, what the potential value might be. I did that before the pandemic, and I do it after the pandemic. So that the fact that the format may be different and that we're doing it by Zoom, because I agree, everyone's caught on to the technology, I think it works. But the thing that doesn't change to be successful is to prepare for mediations. I think if you do that, that's part of what I get back to the motivation of the parties to want to settle. And I think what I've seen when mediations don't succeed is either the lawyers haven't communicated with the clients enough about the downsides of their case. No case is perfect. There's downsides you got to talk about. And so that when you go in, everyone has their eyes wide open and have an objective sense of what might be able to get accomplished. That doesn't change whether the format is Zoom or in person.
That's a terrific thought to end on, because it is, just as you said, coming back to something that we all have heard and know from the very beginning. I will mention before we close that for those of you out there who are contemplating these things but are worried about the technology and worried about it, don't hesitate to ask your arbitrator or mediator for help, or whether their group that they're affiliated with has somebody who can provide you the help that you would need in order to be able to do the most effective job for your clients. With that, I know, as I mentioned, that Judicate West, JAMS, and the others have people who can provide that assistance. If you don't want to go through one of those, try Court Call. because they have people that can help you as well. But I think this is wonderful. Amy, I had to believe that when you were talking about the people who don't want to go out, when I have my pre-arbitration calls and one person has logged on, but the other one hasn't, we're just kibitzing. I'm always asking them how they're doing working at home. And I find that the people who are going to be the most anxious to get out of the house and back into the offices are those with small children. Those who can both teacher and babysitter, etc., while they're trying to run their practices. With that, I'm going to thank Amy, Melissa, Ricardo. You've been as terrific as I thought you would be. Greg and Beverly Hills Bar, thank you very much. And I'll remind you all of the next out of court program, which is, as Greg told us, April 8th, led by Leslie Wallace, and it's employment protocols in the COVID era. So thank you very much for joining, and please join us again.
Thank you so much.
Thanks for having us, Judge.
Thank you so much. Take care.
Bye-bye.
Bye-bye.